This is Def AI, focusing on the newest developments in the AI analytics space. Please subscribe to my channel. High-risk AI has become a new frontier for regulations. If you thought the European Union has enough digital regulations already, then there will be more to come. EU lawmakers are in an advanced stage of three-way negotiations to hammer out agreement on a risk-based framework for regulating applications of artificial intelligence. This follows a draft proposal by the European Commission back in April 2021. The basic approach for the EU's AI Act is to categorize use cases of artificial intelligence as either, in a very few cases, prohibited, high risk, or low risk. With the high risk category, that includes examples such as AI being used in fields like employment, law enforcement, justice, education, and healthcare, being subject to regulatory requirements in areas like data quality and security, and avoiding bias, both ex ante and ex post, launching into the market. While AI apps that are classed as low risk, the vast majority of the use case most likely, are merely encouraged to apply best practices, codes of conduct, so essentially left to regulate themselves. Very few use cases are out and prohibited under the plan. For example, a Chinese-style social credit scoring is one, although discussions to agree all details of the planned law continue still up to this date. The initial Commission proposal also contains some transparency requirements for technologies such as chatbots and deepfakes, requiring that users of such services are clearly informed they're interacting with a machine. However, the draft proposal did not explicitly tackle general-purpose AIs, like GPA AIs, or what is sometimes couched as foundation models. So there's been a concern about a loophole based on makers of GPA AIs technically falling outside the listed high-risk categories, given their technology is framed as multi-purpose, which could let them claim the law doesn't apply to them, pushing all the regulatory risk onto downstream AI deployers, such as businesses plugging into their APIs. It's certainly notable OpenAI has moved so quickly to platformize ChatGPT, opening up the new technology to business users to plug directly into their apps. So it's clear that any risks associated with usage of generative AI technologies will quickly be massively distributed and embedded wherever the technology is being used. And that looks set to be a truly huge surface area, which in turn means AI regulations that don't tackle GPIs had on risk being out of date before they even hit the blocks. Interestingly, peak hype around generative AI deployments has coincided with negotiation towards agreeing a final text for the AI Act, giving lawmakers a chance to propose amendments into plugging the GPI gap, ensuring the likes of ChatGPT will be covered. Last month, Euractiv reported on a proposal to put forward by the European Parliament co-rapporteurs on the AI file to apply significant obligations to GPA makers like OpenAI, akin to those draft applied to high-risk systems, including risk management obligations around systems design and testing, and data governance requirements for training data sets. Additionally, it reported a suggested amendment would require technologies like ChatGPT to undergo external audits to test performance, predictability, interpretability, corrigability, safety, and cybersecurity in line with the AI Act's strictest requirements. It is still not clear how exactly the EU will seek to regulate general-purpose AIs, because we won't know that until the Parliament and Council reaches a final agreement in closed-door discussion. And AI firms like Microsoft and major investors in OpenAI have in the meanwhile already been lobbying for GPI carve-outs. But it seems highly likely the framework will be amended to at least take into account ChatGPT's and also its requirements for general-purpose AI. Okay? Specifically, it will focus on tackle the data quality and fix any issues like bias in training data, since the deployer has in general no access to the training data, with the other responsibilities perhaps pushed onto the deployer since they're attached to a specific use of technology, which the maker of the foundation model is not directly involved with. The new regulation will play a major role in addressing high-risk AI technologies. The EU does have a draft plan on the table to expand liability protections to AI and software. So it's fashioning both fixed rules for risk application of AI combined with the threat of lawsuits for model makers that fail to ensure that products don't scale harms. The liability framework proposal aims to encompass breaches of fundamental rights, so this will be an interesting area to watch. Again, litigation may have a key role in shaping practical guardrails for AIs. This is DevAI, focusing on the newest developments in AI and legal space. Please subscribe to my channel and put any questions or feedback in the comment section. Goodbye.